Good morning, good afternoon, and good evening, depending where you are in the world. Today, we have people from companies, law firms, and regulators from 18 countries in Europe, the Americas, and Australasia, and others in many countries and all continents watching this session. Welcome, everyone, for joining us today for this 90-minute webinar. And the title is Helping Young People to Better Protect Their Privacy and Safety Online. Thank you to Meta, formerly known as Facebook, for sponsoring this session. So I'm Stuart Dresner, founder and chief executive of Privacy Laws and Business, the world's most experienced information company specializing in this field. Last month, celebrating our 35th anniversary. Thank you to many of you joining us today who keep up to date by subscribing to the Privacy Laws and Business P&B International and UK reports, published in alternate months, online, PDF and paper formats. For details on all our services, visit privacylaws.com. Now, thousands of people download our news, and there have been thousands of downloads of our Privacy Paths podcasts since we started releasing them in June 2020. They're available on our website or wherever you download your podcasts. The most recent one on age verification estimation with Iain Corby, who's on your screen, and one of our panel members today was recorded and released on Monday this week. Now, turning to today's subject, I will take as a starting point the image we selected for this event. The young people shown in the picture playing with their devices are early teenagers, confident in their use of online services, no longer young children. They probably resent their parents' attempts to watch over them to keep them safe, but they're not yet at an age where they should access everything the internet can throw at them. In short, this is both a privacy and a child protection issue. Now, the session today will include a wide range of subjects, international instruments on the subject, practical implementation of the best interests of the child, age estimation and verification, the role of good design, how companies are designing age-appropriate safeguards, which countries have taken legislative and regulatory initiatives with the ultimate aim of creating better protections for young people online, and how can policymakers and regulators best work together and with companies to ensure consistent policy and effective outcomes. To guide us through the subject, we have the chair, Professor Nikolaus Forgó, Professor of IT and IP Law at the University of Vienna, Jürgen Bänsch, Director of Policy and Public Affairs, ISFE Brussels, representing Europe's video games industry, Andrew Carroll, Acting Head of Children's Policy at the Data Protection Commission Ireland, Iain Corby, Executive Director of the Age Verification Providers Association and Project Manager for euCONSENT, based in London, Professor Brian O'Neill, Work Package Lead for Policies and Policy Stakeholders, and he's based in Dublin, and Rachael Gallagher, Privacy Policy Manager for the EMEA region for Meta, based in Dublin. If you have any questions for the speakers, please type them in the Q&A section. That's not the chat section, type them in the Q&A section, which you'll find to the right of your screen. Type in the questions when you think of them, although the plan is to take questions after the panel session. A recording of the video of this 90-minute session will be available to you afterwards, and you can access it anytime on our website. Over to you, Professor Nikolaus Forgó, who will introduce our subject.
Thank you so much, Stuart. I must say that I'm very, very excited about this opportunity to talk about a subject that I'm frequently confronted with for at least two reasons. The first one is, that's probably the more important one, being a father of a 20-year-old girl and an 18-year-old boy. I have been struggling through the issue that we are talking about for quite some time now. And the second reason is that I'm also concerned about the topic, obviously, for professional reasons, being a professor dealing a lot with IT and in particular data protection related matters in Europe. One of the things that I have been doing here, and that's probably one of the reasons why I'm here, is that I'm in charge of a project which is called Privacy for Kids. And that's a project that tries to help young people, but also their parents, to understand better about their rights and about their duties and about the risks and the opportunities coming with the internet and their online life. So very excited to be here, and I have the plan to speak as little as I can in order to learn as much as I can from our distinguished speakers. And the first topic, obviously, I must excuse myself for this, being a lawyer, is about the regulatory framework and in how far the things that we are dealing with are covered or are not covered by laws, and laws from different hierarchical levels, starting somewhere on the UN level and then being drilled down to the European and the different national levels. So perhaps I may invite Brian O'Neill first, being an academic as well, to give us an overview at the beginning about how the UN regulatory framework looks like when it comes to the rights of children, and how this is then going down the path to European and OECD and other norms that are of relevance here. Brian, please.
Sure. Good afternoon, Nicholas. Thanks so much. It's great to join you. And I should say that my background is a media and communications scholar, and I've got a long-standing interest in looking at the whole media environment and how young people participate in and benefit from the media environment. And of course, that has changed so much that policy and regulatory frameworks have evolved into this changing kind of environment. So that's the kind of perspective, that I bring. So, in that context, I suppose one of the first things to see is that we really are in a new phase, I think, in terms of our policy thinking. And there are many ways in which we might sort of define milestones around this, but where for many, many years, the whole context was defined by protection and the need to protect young people in what was seen as a largely unregulated sphere, and something that was clearly not designed with children or young people in mind. And that in itself posed a whole range of dilemmas and gaps in our policy provision. And central to this, I think, has been the growing recognition and awareness of the rights of the child. And to take the UN framework, the Convention on the Rights of the Child, as one of the most ratified international treaties to which all governments subscribe and have signed up to. But in terms of understanding what that might mean, for the full spectrum of children's experiences and so on. So I think that marks a significant sea change in both policy formulations and in terms of thinking in this environment. So this has happened in a number of different ways, and I think a number of different standards that we might point to. I should say I think the Council of Europe likewise has made significant contributions to this discourse and this understanding. Of course, the Council of Europe, in terms of its promotion of democracy, human rights, and the rule of law, is concerned with a number of key dimensions here, including the media dimension, in terms of the governance around that space, and in terms of children's rights. So they made an early I think commitment towards recognizing and underlining the significance of recognizing children's rights in this digital space. The UN Committee on the Rights of the Child themselves have likewise, given careful consideration to what its provisions and its understanding of the key principles of children's rights were formulated long before the internet and long before, indeed, a media environment with which children are so involved. But through that consideration, have now developed, much more detailed guidance. And last year saw the adoption of a general comment in relation to children's rights in relation to the digital environment, which accompanied, previously the Council of Europe's own recommendation on protecting and fulfilling those rights. And then even most recently, we've seen the OECD in terms of, its recommendation to member states and to governments and updating its previous guidance in terms of, that a rights-based foundation is the appropriate level on which we need to now think about what our policy formulations are and how our frameworks need to recognize both the position of children as rights holders, and that is the child up to age 18, and in terms of what that translates to in terms of responsibilities of key stakeholders, and where much of this advice is towards governments and putting in place the appropriate policies and legal frameworks. It has concomitant responsibilities and key recommendations for all our stakeholders. So that's something I as a researcher and somebody involved in trying to bring evidence into this discussion. I'm very interested to see how that can assist in this process of now a somewhat new dispensation. And we have now some significant landmark legislation, regulation in the form of the GDPR, in the forthcoming Digital Services Act, in terms of some key areas which now consider children within that context, and within which best interests of the child become a foremost consideration. So that's the context in which I would place it, and say perhaps it's a jumping off point for many of our discussions today, in terms of how it stems from now what is a growing international consensus around some of the key questions and the ways in which we should be approaching that.
Mm-hmm. Thank you so much, Brian. I think one of at least two key messages I would take with me. The first one is there's plenty of text and plenty of things that are on paper that need to be brought into life, and hopefully they are brought into life. And the second message is Europe plays an important role in this. GDPR, DSA, DMA, etc. Those are European documents, and it's very interesting, therefore, to learn now from Andrew, if I may ask you, to learn a little bit more about how all these texts are then implemented in real life in Europe, in a European Data Protection Authority on a daily level. Andrew, please.
Thanks very much, Nikolaus, and thanks very much to Privacy Laws and Business for the invitation to speak here today. From our perspective as a regulator, it's very encouraging to see, as you referenced, Nikolaus, the significant number of data protection regulators who are producing guidance and codes and instruments on the processing of children's personal data since the entry into force of the GDPR. So obviously we have in Ireland our children's fundamentals and the 14 data protection interpretive principles that they set out for organizations that process children's personal data. Our audience will have heard of the ICO and its children's code and the 15 legally binding standards that it sets out. Similar work has also been carried out during this period in France by the CNIL, which has produced guidance on children's rights last year. The Dutch Data Protection Authority has produced a code for children's rights. The Swedish DPA has also produced its own guidance. So it's great to see so many of our colleagues who are seized of the importance of this issue and who are producing guidance that is very much needed for online service designers. And as Brian O'Neill alluded to, a reoccurring theme across all of these documents is that they draw upon the Convention on the Rights of the Child, and in particular the best interest principle. Most of them have a certain number of standards that summarize their core recommendations, 10 or 15 standards, and we see that almost all of them reference the best interest principle to some degree. So it's the very first principle in the Children's Code. It's the very first principle in the Dutch Code for Children's Rights. And of course, in our own fundamentals, we say that our core message is that the best interests of the child must be the primary consideration in all actions concerning their personal data. So it's something that we see again and again in these instruments. And what this reveals is that the Convention's best interest principle has become the single biggest interpretive source for the high-level principles of the GDPR. And this is because, as Brian said, the convention is binding upon all signatory states. It's the most ratified convention in history. And both the Court of Justice of the European Union and the European Court of Human Rights have recognized the binding nature of the convention. And in particular, the Court of Justice has held that the primacy of the interests of the child, which is Article 3 of the convention, is the prism through which the provisions of EU law must be read. And then separately, of course, the Committee on the Rights of the Child has produced numerous general comments which affirm that the provisions of the convention apply not just upon state parties, but in the commercial world and in the digital world. And so this is ultimately why data protection regulators have turned to the convention to put flesh on the bones of the high-level principles of the GDPR. And you can really see this if I take the example of our own guidance, where we have made the best interest principle the golden thread that ties all 14 of the standards we set out. To give a couple of quick examples, in our section on legitimate interest as a legal basis, we say that in the balancing exercise carried out where children's data is concerned, there can be no negative impact upon the best interests of the child at any level, where legitimate interest is the legal basis for processing children's data. When it comes to transparency, we say that transparency information must be provided directly to the child user in language that they can understand as per their right to be informed, both under the GDPR and under the convention. And our guidance on data protection impact assessments says that controllers should specifically consider the risks to child users with the best interest principle as a key criterion. So these are all examples of how we've taken the keystone of the convention and applied it to the GDPR. But as a regulator, it's important to say that we knew right at the beginning of this process that we were not experts in this field. We're not experts in child development or child psychology. So it was very important to work with the established experts in Ireland and further afield, which is why we partnered with the Irish Ombudsman for Children's Office in creating our consultation, which itself drew in as many experts in all the relevant sectors as possible. And that's why our message to service providers on this specific question is that it's very important to invest in the necessary expertise to design services with the best interests of the child at their center. And this means consulting with child development and child safety experts, investing in the necessary staff and training to ensure that the 4 key principles of the convention are embedded in your service. So one of these is obviously the best interest principle, but there's also the child's right to non-discrimination, the child's right to life, survival, and development, and the right to respect of the views of the child. So, this is essentially what it means to design services in the best interest of the child. And of course, there's no easy answer to this. It does require additional resourcing and will require controllers to have specialists in these areas that I mentioned, child development and children's rights and child psychology. But ultimately, this is the price of doing business with children, because as we've mentioned earlier, children have been overlooked in the digital environment for too long, despite the fact that they are 1/3 of internet users, and they are, globally, and they are a highly influential and lucrative market for online service providers. So designing services with the best interests of the child, in short, means recognizing children as the important market and audience and cohort that they are, and incorporating the specific protection that they merit under the GDPR from the get-go, and not as an afterthought.
Mm-hmm. Mm-hmm. Andrew, if I may, I would have 2 additional questions on this. The first one is, what is the role of the parents in this? So how could parents in this play a beneficial input and provide a beneficial input? And the second question related to the first one is, are you dealing with the proper information of the parents? Because I think one of the issues that parents might have is that they simply don't know what their children are doing, and they have a conflict of goals here. On the one hand, they don't want to be the police state in the living room, right, controlling everything that the children are doing. And on the other hand, you need to know what your kids are doing in order to be in control of what they are doing and in order to protect them. So how can an authority like the one that you are working in help parents as well?
That's a very good question, Nikolaus. I suppose in relation to the first part, the role of parents, of course, parents have a tremendously important role as, the custodians of their children's rights. I suppose early on in our project, we realized that one of the biggest misconceptions that we needed to address was that children are data subjects in their own rights, and they have rights in relation to their data at any age. And so it was important for us to impress upon the fact that even though of course there are many situations where parents will exercise their children's rights in the digital environment, that there has to be awareness of this kind of this primary imperative that ultimately it is the child's data. And when there are situations where the rights of the child to exercise their data protection rights are in conflict with the interests of the parents, that will prevail, provided it's in their best interests. But regarding the provision of information to parents, that's of course very important. One of the things that we're working on is a series of bite-sized guidance materials for children to explain their data protection rights, but also a document for parents to help them accompany their children in the digital environment. And another important element of this is that if you explain data protection in language that's easy enough for children to understand, then it's easy enough for parents to understand, and it's useful for parents as well. And one of the things that we've discovered is that by forcing ourselves, all actors in the digital environment to simplify what data protection is about as easily as possible, in as simple as terms as possible, that makes a very useful resource for parents as well as children. So that's our vision of the role of parents.
I see. And a second question, if I may, Andrew, going to you, which is, would you consider the Irish Data Protection Authority here being in line with all the other European data protection authorities, and do they have a joint view on the issue, or do you see any major differences within Europe?
Well, I don't necessarily see any major differences, Nikolaus. I mean, my impression from reading through all the different sets of data protection guidance that have been published by our counterparts in other jurisdictions is that we all agree on the fundamentals that about the importance of protecting children's data. I think as I said, our journey in creating this guidance is we found ourselves prioritizing the areas where we found the biggest misconceptions. Other regulators might have other areas where they think that guidance is more of a priority. So the French the CNIL's guidance on children's data protection rights puts specific attention to the role of parents. It has 3 separate standards on the role of parents, whereas ours doesn't have a standalone principle devoted to the role of parents. But that's not to say that there is a disagreement in this regard. No.
I see. Okay, wonderful. I mean, one of the points that Andrew and also Brian mentioned explicitly is the point of the best interest of the child. And that's a beautiful term because it's so legal, right? It's so abstract and there's so much space for interpretation there. And therefore, I would kindly invite first Iain and then perhaps Jürgen in this order to give me a first introduction into how you understand this term and how you help to implement this term. And I will then finally ask in this round Rachael to comment on what she's hearing at the moment. So Iain, perhaps first, what is this best interest of the child in your view and from your background?
Thank you very much. Well, I represent 22 providers of age verification technology. And what we're about is essentially figuring out the age of a user. And I think whenever you want to apply any sort of differential regulation or protection to children as opposed to adults, or increasingly these days, different age ranges of children under the age of 18, so discriminating between younger children and older children, the first problem you have is knowing the age of the user. There's a great cartoon showing 2 dogs playing at a computer, and one dog turns to the other and says, "It's great. On the internet, nobody knows you're a dog." And this is the problem we have with the internet. Nobody knows whether you're an adult or a user. And historically, we've typically done this by elimination. So we've asked adults to prove that they are adults, and therefore assumed that anybody who can't prove they are an adult is a child. But increasingly, we now have techniques where we can ask children to prove their age, often using artificial intelligence and age estimation. So it's not a direct answer to your question about the best interests of the child, but I will stick to my brief, which is we're here to help you figure out which are the children whose best interests you then need to support.
Okay. Well, just one remark, Iain, if I may. I think the cartoon you are referencing to is from 1993, so it's 30 years ago already. So what changed in these 30 years that makes you optimistic that the problem is better addressed now than it was addressed 20 years ago?
Well, things have only really become addressed in the last 5 years or so. It's a relatively young industry that I work for. It was driven by the UK decision to implement a requirement for age verification online for accessing adult content, which in the end the government declined to implement. But that's literally tomorrow, the UK government will be announcing the same scheme. It'll be solved with pretty much the same technology. So we had solved this problem of how do you prove your age, particularly in a privacy preserving way, which at the time, 5 years ago, was important for pornography, but it turns out is really important for children as well. So how can children prove their age online without handing out their full identity to any website they happen to want to visit, which clearly I'm sure we'd all agree is a very bad idea, that children would be bandying around their identity in that way. So I think certainly it's moved a lot in the last 5 years, and we're now in a very strong position to deliver age assurance to websites who need to know the age of their users.
Yeah. So I think one of the answers that one could give then from your perspective on the question, what is in the best interest of the child, is not to be asked to offer all the privacy relevant details to every website you're accessing just because you want to prove your age, right?
Yeah, indeed. I mean, I always explain it as when you walk into a bar, the barman doesn't need to know your name. He simply needs to know that you are old enough to buy a drink. And so there's no justification, and you can apply, good data minimization principles here to say the only thing you ought to need to prove is your age, nothing more.
So data minimization, again, a very, very old traditional principle of European data protection of new and even more important relevance today. Thank you so much, Iain. Jürgen, so help me in understanding what is in the best interest of the child from your perspective.
Thank you, Nikolaus. I must say, when I was first reading one of the first drafts of the ICO code and reading about the best interest of the child principle, putting so much in the center of it, my first reaction was, well, we have been doing this for a long time now. Most of the work we as a video game industry have been doing needs to be seen in the context of PEGI, the Pan-European Game Information System, which is basically a network of more than 2,500 companies, so spanning basically the whole video game sector. A network that is based on a code of conduct, based on a couple of principles, and that is targeting engagements in the context of not just age ratings and age-appropriate design, but also online safety, advertising, privacy, and so forth. Now, the definition of best interest of the child is systematically considering how children's rights are or will be affected in the context of a certain environment. Now, when it comes to making that type of assessment, I think we need to take also into account that children need particular protection because they might be less aware of risks, they might be less aware of consequences and so forth. So there is a certain amount of tension between what I would call a restrictive approach and a more full-scale approach, full empowerment. And companies need to make that type of assessment. And that is exactly what we have built in the context of the PEGI system. It is an engagement beyond the law that provides for, I would say, a framework of age-appropriate design, engagement for online safety, but also an encouragement, an active encouragement for active involvement of parents. Because when it comes to the point where one needs to decide whether or not children are mature enough to exercise their rights themselves, I think it's very important really to have an active involvement of parents, whereby parents can engage with their children and take an interest on what their children are doing, explain to their children why it is important to exercise rights, what are the risks, what are the consequences of doing that. And we have been actively involved really also to provide them with the necessary tools to do that in the context of parental control tools, in the context of campaigns, and so forth. So those three elements, I think, are really the framework against which we offer tools to the companies really to make the assessment about the best interests of the child.
So again, parents play a role in this, right? That was your ask. And how do parents react on what you're doing? Do you think? I mean, the problem that I have when I talk to other parents is most of them are simply not interested, right? So it's somewhere, it's a black box what their children are doing. So how do you help them in breaking into this black box? Is it just that you try to explain to them, or is it that you do some kind of nudging?
Well, both.
In gaming too, right? Wouldn't they?
It is nudging and explaining to them at the same time. So we are running awareness campaigns now, I think in 16 European countries, where we actively want to explain how parental control tools work, but also how to start a dialogue with the children and take an interest. That is one. Nudging by use of the parental control tools as well. So you can play video games on many different devices. All of them have parental control tools now activated. And the way it usually goes, when you set up the device, you are forced to make a number of decisions on the level of filtering and on the level of the device itself. And we think it's extremely important that parents are forced to make those decisions, because that way they will be forced to take a number of conscious decisions about the appropriateness of the devices and of the games and the content for their own families. So we have a little bit of a problem with recommendations about putting certain safeguards by default on the devices. We think it's important really to nudge parents to take a number of conscious decisions, and that is what we are trying to do also with the setting up and with the format of the parental control tools.
I see. Thank you, Jürgen. So Rachael, let's dig a little bit deeper into industry practices by looking into one very prominent case, which is obviously Meta. Could you comment from your perspective, please?
Certainly, Nikolaus. I suppose I should say is that the best interest of the child concept has brought a whole new meaning to me on a personal level, as I'm expecting my first child in June. So this is really bringing the concept into reality for me. But to borrow on a phrase that you've used around the best interest of the child concept, I mean, not only is it an abstract concept, but also a dynamic one, which I think the UNCRC general comment also picks up on. And why this is important is that the dynamic nature of it requires really organizations to carry out an assessment of the various rights that a child has in any particular given situation, and to make certain decisions about maybe the particular processing or product or feature. And really what's important is actually bringing this principle to life. So it's all very well at being like an abstract policy concept, but what does it look like in practice? And really at Meta, that all begins with the product teams. So one way in which we've tried to address this and really get to grips is by developing an internal framework over the past year, which helps bring this concept to life. So using the UNCRC, the IDPC Children's Fundamentals, the CNAID recommendations, the ICO Age Appropriate Design Code, we've actually created like company-wide values and a framework for product teams, which helps guide product development essentially. And it distills all of these frameworks into 6 key considerations. And these include things like the requirement really to recognize global youth and families. So it's not just about like thinking about one region or one country when we're developing products. We have to step back and look at it from a global perspective. Obviously, other key considerations include things like creating safe, age-appropriate experiences, promoting youth autonomy, which is a key one, particularly whenever parental supervision and controls are involved. And obviously, things like promoting well-being, safety, and privacy, with the key, I think, imperative to try and empower youth and help them understand and exercise the rights that they have. And what we found by creating this framework and this kind of principle-based approach is that it not only helps to create consistency across jurisdictions and across the family of apps, but it also helps to bring a youth focus to Meta's existing and the new products that it will develop as well. So product teams have really found this super useful, and the key considerations which we've developed, those are supported by guidance, examples, context, workshops for product teams, just to actually bring this to life. I would say, just to touch on one more point, the other key thing I think in thinking about the best interest of the child is to hear directly from young people and parents and guardians and families themselves on this. And I know even, for example, the IDPC fundamentals, I mean, Andrew's office conducted a wide range of consultation and produced in their guidance. But this is really a core part of building and designing with youth, the best interests of youth in mind. And it's certainly been central to our approach. Just today, actually, and this is purely coincidental, we've just launched parental supervision tools on Instagram. And this will be rolled out globally in the coming months. And also we will be rolling out parental supervision tools on Quest 2. But again, the best interest of the child was a key concept which we really needed to get to grips with and balance very carefully in actually designing the tools themselves. Mm-hmm. So I'm happy to provide more flavor as we go on, but don't want to take up too much time in the conversation either.
Okay. Thank you so much, Rachael, for this very interesting first introduction. I think one of the things that I take with me in this first round is it is important to know how old the child is. And second, it is important to know who is giving which kind of consent / legitimate interest / whatsoever legal basis, also from a European perspective in particular. So Iain, there's a question in the chat, mainly going to you, probably addressing both of those questions in a way. Somebody's asking here, in using AI or other age verification techniques, you are collecting more information about the child. What kind of privacy risks do you anticipate, and how can we mitigate those risks? And if you take this, perhaps I may also invite you to give us some examples of best practices, in your view, how to deal with these issues.
Yes. So I would say, first of all, we always work from the basis that the only sort of non-hackable database is no database at all. So the starting premise in terms of privacy by design for our industry is not retaining personal data. So once you've completed the age verification process, however you've proven your age, we don't need to retain any of that personal data. We just need to remember that you, as a user, and you might be user 123, or you might choose the name Mickey Mouse, but we just need to know that that particular user has a certain date of birth. And then from then on, we can answer questions: is Iain over 18? Is Iain under 13? With a simple yes or no answer, without actually passing a lot of personal data from place to place. Now, of course, if you're particularly sensitive about your personal details, then you can use some of the artificial intelligence approaches where we're estimating your age based on, for example, facial analysis, which we have got down in the industry to an accuracy of under 3 years either side of the actual age, pretty much for all age groups. And in fact, it's even more accurate for younger people. And we've got that at an equal basis across different skin types, which was one of the early teething troubles with that particular technology. So you can actually do it simply by using a facial image, where in fact you're not necessarily keeping any, well, not even using any personal data, because you can't use the data we use on the image in order to reconstruct the picture. It's simply a mathematical construct of your image, which is then thrown against an algorithm to try and figure out your age. So there are both in the way you actually do the check in the first place, but then in also how we maintain that record going forward. Then we don't need your personal data beyond the one thing that we're helping people with, which is obviously your age.
Mm-hmm, mm-hmm. Brian, perhaps going to you then, and then to Andrew, and then to Rachael. This AI topic, obviously, is something which is very hot at the moment, in particular in Brussels, but not necessarily when it comes to age verification. Do you see the relation here between age, AI, and data protection? And do you think that this is properly covered at the moment on a regulatory level?
I'm not a specialist in this area, but certainly the role of AI is so significant across all digital services that it just becomes central to what we need to address in terms of policy and regulation. So, Nicholas, you've been you focused on the role of parents. This is something that is very opaque to parents. It's something that they don't really understand. How do platforms work? What kind of information are they collecting, and how transparent is that to parents who may have concerns about their children and what they're accessing? So in terms of the requirements really are towards as transparent as possible. And in terms of, obviously the whole principle of data minimization. And remember that I think, we've been speaking about, let's say, children perhaps over the age of 13 or teens, and sometimes that can be more of a struggle for parents to understand all the apps and services that they use. But we're talking about children from 0 to 18. And the very youngest children who make their first steps through the digital environment, whether it's through connected toys or tablet devices around about the home and so on, they're navigating digital tools and technologies and services at all stages. And there are important issues there in terms of data traces and who in the home is actually overseeing that or consenting to that use. So it does present a range of quite important pressing challenges, I would say, in what is obviously a fast-moving environment.
Yeah. So it's about educating the parents, but possibly it's also about educating the data protection authorities, Andrew, isn't it?
Yeah, that's an interesting question, Nikolaus. I suppose one of the interrelations between AI and the question of age verification is that of course AI is one of the tools that is increasingly being deployed to infer the age of users. But I think it's important to point out at the outset that age verification, which I'm going to use as a shorthand for all these different tools, from age inference, age assurance, etc., which might irritate Iain slightly, but it's how we set things out in our fundamentals. But it's important to point out that this isn't actually a requirement of the GDPR. But what has happened is that age verification has come to the forefront in recent years because of the need for service providers to know who their audience is, and that ties back to the core question of this whole panel, which is how one of the core themes is how do you know what protection to provide if you don't know who your audience is. So the need to know your audience, which is also one of the standards that we set out in our children's fundamentals, is really where we're coming from in terms of age verification and how it is the gateway to compliance with the GDPR standards. And other members of the panel will be able to speak with more authority than me of the range of different methods that are available for assessing or verifying age. Ranging from the age gates and hard identifiers, copies of government ID, to third-party verification services, cross-account verification, parental verification, which we alluded to just now in the role of parents, or these capacity assessments and knowledge checks where you get the child to fill out some kind of questionnaire, or biometrics and facial recognition technology, as Iain was talking about just now, or even flagging, which is where you get other users of the service to report on suspected underage users. But I think the main takeaway for regulators is that each of these solutions has their own trade-offs or strengths and weaknesses. So some are not very robust, such as age gates. Some are going to be disproportionate in almost all circumstances, like copies of ID, or they're going to trigger privacy concerns. And some are still very much in development, such as using profiling or AI. Based on our engagement with companies on this, our understanding is that whereas profiling now it's very effective in terms of assessing in broad terms whether a user is an adult or a child, it gets more complicated when you're trying to assess whether a child is just above or below the age of digital consent. So this is an area that is still very much in development, and it's something that regulators but also companies are grappling with. So because all these tools have their own limitations, companies that want to go down this route will have to consider very carefully which methods are the most effective in their context based on the risk to child users. And ultimately, the right approach is going to be what is most effective. So this will entail ongoing user testing and efficacy testing, which online service providers are or should be doing already, and regularly revising their risk assessments. And it's not a process with an end date, because controllers have to demonstrate that they have the procedures in place as a matter of good practice, and that they are keeping abreast of the latest developments and research. I mean, one final point, I suppose, from our perspective, the challenge will be ensuring an objective assessment of the risks to child users based on the best interest principle, because if that assessment is off, then the age verification tools that you're going to put in place are going to be off as well. And this is why, again, we say, and I'm going to keep banging the drum for this, but a data protection impact assessment with the best interests of the child at its core is really your starting point for compliance and providing the specific protections that children merit in this regard.
Absolutely. I completely agree with you that the DPIA is a centrally important tool for this. And I would really like to learn from Rachael and then from Jürgen about how they see this in practice. So whether there are any best practices in your company or in your association that you might report on. Rachael.
Yes, certainly, Nikolaus. Well, I think actually, Andrew has said it very well whenever he said, this is an area that's still in development. And verifying age online, it's not as simple as it might sound. A lot of sometimes policymakers point to identity verification as being like the holy grail or the silver bullet, but there's challenges with that as well, which Iain has touched upon earlier. The other thing I would say, there's different equities really that need to be balanced when we're considering age verification. So like as a company or as companies, how can we verify age to a sufficient degree of accuracy whilst not locking out millions of users and potentially impeding children's digital rights? So there's a balance to be achieved there. We know, for example, in the case of hard identifiers or identity verification, that a lot of countries in the world don't have maybe national IDs. And so as a result, women sometimes in particular can be disproportionately affected. So that is something that we need to consider as well. The other key thing, and I think the IDPC fundamentals and ICO age appropriate design code do touch upon this, is the need for proportionality. So not all use cases will require the same degree of age verification. And it should be very much that the stricter layer or the stricter levels of age verification should be really reserved for the areas or the processing that really are posing the greatest risk to children. And then the other thing, which is I think is an interesting element to throw in there as well, is parental decisions as well. So we know that there's some research out there that shows that parents and guardians actually want discretion to decide when their young person, when their child is actually old enough or mature enough to access content. And so this again adds an extra layer of complexity for industry. So that's all to say that we don't think that there's a silver bullet, and I think lots around this table would agree that there's no one size fits all. And so our approach is very much to have this multi-layered approach. So it shouldn't focus on one single step and one method of verifying age, but instead a collection of ongoing efforts to provide an age-appropriate experience. So the age assurance dimension is obviously very important, but also the more holistic dimension of making sure that there are safety and privacy safeguards on the platforms, as well as age assurance tools. We find this to be the most effective way forward at present, at least.
I see. And Jürgen, from a more, I would assume not so much company, but industry-based point of view, what would you say?
Well, actually, I mentioned already a lot our focus and support for parental control tools. Parental control tools allow for parents to set up child accounts, and by doing so, it is the parent that will determine and certify that the child is a child and that the child has a certain age. The way this works is usually when somebody is registering for an account, the date of birth will determine whether or not you will qualify for a normal adult account. And when that is not the case, then there's basically, you have three possibilities. Either the child has no access to the game, or the child has an access to the game on an offline basis, so when he can play the game, but he cannot communicate with others. And then the third possibility, and mostly used, is that the child can access the game as a child account. And then this means that the child will initiate the creation of the account, but it's actually the parent who needs to finalize that process, and who needs also at the same time to make a number of opt-in decisions, mostly regarding consent-based data processing activities. Things like allowing the child to share gameplay, allowing the child to share account information, to share data with third-party providers, advertising, and so forth. And so this is actually, I would say, one of the main processes that are used and operated in our sector. Now, you may think that the weak spot here is obviously the self-declaration process at the start, where the child needs to indicate the age. But that is also linked to a number of, I would say, safeguards. Resubmitting is often not possible for that. Some provide for a limited number of attempts. And it should also be said that not all children immediately try to circumvent certain protection tools. A lot of the children actually self-protect as well. So self-declaration is maybe not an ideal way of starting an age assurance process, but it needs to be seen, I think, also in proportion to the risks that are involved, which are usually also quite limited. Now, obviously, additional systems would be good if that can be implemented by the industry. There are a number of concerns there, but I think that is also why we are very supportive of the work being done by euCONSENT. If euCONSENT can provide for a system that technically a digital industry can implement easily and on a cost-effective basis, that would be great, of course. There are, of course, a number of concerns here. From my perspective, one of the most important one is that an age assurance or an age verification system needs to be able to deal with the lower age thresholds. So we're not talking about 18 plus 18 minus here. We're talking about certifying whether or not a child is 12 or 7 or anything like that. And so there are no databases out there that contain that type of information. So then you need to revert to some of the more technical tools, which sometimes are lacking efficiency. And that is, I think, one of the main reasons why some of the companies are not so enthusiastic about them. Efficiency is quite important. And when companies want to consider implementing an additional system, it is quite important that the level of certainty is higher with the new systems. So I think that is an important aspect to take into account. Another one is, of course, scalability. We are an industry that provides services for users around the world. So a system that can be implemented on a pan-European, if not global basis, would certainly be better. And it's fair to say that that we are still waiting to see something like that to appear on the market.
Good. That triggers two questions to Rachael and to Andrew, what you're saying, Jürgen. Both of them, in my view, being rather important. The first one is, Rachael, I heard with a lot of interest what you were saying about the efforts you are taking as a company at the moment, but I would assume that similar companies in similar sectors are taking similar considerations at the moment, and I would be very interested in how far it is possible to communicate on this on a sector-specific or even on a global level. And the similar question then going to Andrew, in how far can data protection authorities steer or trigger or incentivize such initiatives?
Sorry, could you just repeat the first question, Nicholas? Sorry.
Do you exchange on a regular level all what you're doing in the field of age verification with competitors in the market or with other major companies in the market? And is there a forum for this, or is it every single one trying to learn your own lessons out of this?
Yeah, and it's a great question. The way we would normally do it, Nicholas, is if there's maybe a consultation, say for example the IDPC is running or the ICO, where we would share more about the approach that we're taking. But this seems to be maybe a gap that's there at the minute, in terms of not only industry, but industry, policymakers, regulators, parents, and young people as well, and actually coming together to formulate like what the answer should be to some of these things. So one of the things that we would definitely call for in terms of greater alignment is greater alignment across all of those stakeholders, because it's not just about what industry is thinking about doing. It's really to get to a solution which is in the best interest of the child, having that dialogue with all of those stakeholders involved. So I think that's something that we would greatly welcome, for greater clarity, greater consistency, and more collaboration with all of those stakeholders.
I see. And Andrew?
So I'm not really sure that it's for regulators to single out examples of good design in terms of age verification or any other aspect of data protection. I think our approach is more to to encourage industry to innovate in this area based on general, technology neutral principles and guidance provided by regulators that can stay relevant as the sector evolves. But of course, there's you can do more to play a proactive role in this regard. I understand that the ICO has done some very interesting work on its regulatory sandbox, and I believe that the CNIL has a similar initiative, underway, a similar regulatory sandbox. But I think that to touch upon some of the points that were made previously in terms of what successful design looks like, I think that a missing piece is ensuring digital inclusion. So it should ensure that children from single parent families or separated families who don't have regular access to their parents don't have a riskier experience online because all the responsibility is put on parents, for example, or there's an over-reliance on parents to verify age. But that also applies to the point that Rachael was making earlier about children from lower income families or the developing world themselves not having a less privacy protective experience because they can't afford the fee paying services that don't collect personal data in exchange for the free ones that do. And this is actually an issue that's recognized in General Comment number 25 by the UN Committee, which states that if digital inclusion is not achieved, then existing inequalities are likely to increase and new ones may arise. So, but I think one area where regulation and guidance can really play a transformative role is ensuring that age verification isn't seen as a tool to restrict children's access to the digital environment or to shut them out, but actually to try and encourage the development by industry of new products and services that are actually designed with children's privacy and their best interests at their core. Because as I mentioned previously, this is a very lucrative and influential market, and so all the ingredients are there to get industry round the table actually designing more online services that have the best interests of the child at their very heart.
I see. Okay. And I think one of the examples of an attempt to bring industry together that was already mentioned in the chat, and Iain, perhaps you would like to comment a little bit more on euCONSENT and what this is and in how far it plays a role.
Yes, thank you for that opportunity. I'm, as well as running the Trade Association, I'm a project manager for euCONSENT, and this is a project funded by the European Commission and instigated by the European Parliament in response to industry saying, well, you want us to apply these age regulations across the internet, but there really is no good mechanism for us to do that at the moment. And the current approach is you go to a particular website, and if they do apply age checks, they'll refer you perhaps to an age verification provider, and you'll do a check. But then if you go to a different website and they use a different provider, you'll have to dig out your passport and do it all over again. So what euCONSENT is designed to do is to recognize a user when they've done a check previously, and then simply refer that user back to the original provider where they did their check, who can in turn confirm their age, so that you don't have to repeat the check. So it's about interoperability across the AV providers. And we've been working on that for the last year. We've just done a pilot with 1,600 people across 5 countries in Europe, adults and children. Because another element of this is also just making that process of getting parental consent a little easier when a child is below the age at which they can give their consent for their data to be shared, and they need to therefore bring in a parent or a guardian to give them that consent. So we're just trying to streamline those two processes so that we can work alongside some of the large platforms, which will do their own AI-based estimation, absolutely. And in many cases, you don't need to be 100% accurate, and that will be more than fit for purpose. But where perhaps there are edge cases, people who are being estimated wrongly by the AI, those platforms would be able to reach out to anybody in this new network that we're creating, and hopefully, without bothering the user too much, be able to reuse an existing check they might have done to put an order in for a bottle of wine when they were ordering their last supermarket order, for example, or when they wanted to gamble online, or any reason why you've needed to prove your age once can then be reused for any other purpose. And we're very grateful. In fact, we have 3 of the other people on this panel are represented on our advisory board for that project. So Jürgen, Rachael, and Andrew. And by the summer we hope to have something which is operational, because we just recognize we don't want to be the next cookie pop-up. If every website you go to, or even in fact pages within each website, suddenly require you to do a new age check, people are going to get tired of that pretty quickly.
Mm-hmm. Wonderful. Andrew, if I may ask you, Iain said that you are on the advisory board, so I assume that this is of interest for a data protection authority. What is the role of a data protection authority in an advisory board here? Is it just to give advice, or is it also to have a little bit of a closer look into GDPR compliance already from the beginning, so that privacy by design, for example, is really properly incorporated into this?
Well, it's a little bit of all of that, Nikolaus. So we're delighted to be on the advisory board for the euCONSENT project. We're not the only regulator on the advisory board. I believe there's also audiovisual regulators who are on it. We're following it because of all the reasons that we've been discussing today. Age verification is it's such an important part of keeping children safe, and being able to create this kind of interoperable framework that would effectively mean that you verify once, and then the child has an experience that's both safe but protected would be a wonderful thing to achieve. And we're purely there to follow the progress of the project, but we're happy to offer advice on compliance when we're approached for a query. But it's part of the day-to-day bread and butter enforcement of regulators. You also answer queries from regulated entities. Yeah,
but normally they are easier to answer, right, than from research projects that last several years. Yeah, and Iain, if I may come back to you once again, because there were rather technical questions in the Q&A section, and some of them might be of interest to some other people who had not the opportunity yet to follow to them. Could you perhaps give a little bit more of first-hand insight on the technical aspects of AI-based age verification? So how mature and how properly to be used this technology is already at the moment, and how much of this is still science fiction?
Well, it's certainly not science fiction. Millions of age checks are being done using age estimation techniques at the moment based on machine learning. And it really is a case of looking for any aspect of you which changes with age. And as long as something changes with age, then it's susceptible to machines learning how to estimate your age. And of course, what you can do is to combine some of those estimates in order to get even more accurate estimates. So, I mean, really the only show in town commercially at the moment is facial estimation. And I put in the chat some of the detail from Yoti, one of our members, about their levels of accuracy at the moment. And you see, for this sort of crucial age around 13 to 19, they're within 1.5 years of accuracy with facial estimation. But we have other members who are working on voice print analysis, other behaviors like how you might use a games controller, for example, in Jürgen's area, how you might type if you're typing language, or and using some social media, for example. So there's plenty of ways to estimate age, and I think this will become, because it is so privacy preserving, where you don't need to prove that yesterday was your 18th birthday, which is probably never going to be possible with estimation, but for many other reasons, particularly if you allow a bit of a buffer. So say it's about selling alcohol. If you test for the age of 23 using the AI, then it's extremely unlikely, maybe less than 1% chance that somebody under the age of 18 would pass a test looking at whether they're 23 or not. And it's that sort of approach which allows us to use estimation for the vast majority of adults without having to require any more detailed personal information.
I see. Okay. So if I may, I would like to come back from the technical aspects a little bit back again to the regulatory parts and to the social parts, and have a little bit of a closer look into what exactly there is on a legislative and regulatory interventions level. And perhaps, Brian, if I may ask you to give us again a little bit of an overview about how the regulatory part of the field looks like, in particular when we look into the EC Better Internet for Kids strategies and other strategies that were not mentioned yet, and in how far they might play a role as a best practice approach.
Yeah, yes, indeed. No, thanks, Nicholas, because I think, it helps position this debate for us. We're having quite an intensive, close debate here on age verification, but we've got to, put that in a wider picture in terms of, there's, significant political interest in terms of the digital environment and how policymakers need to position, for the public and, for the common good, the effective relationships here. So, children, have had varying degrees of policy attention over the years. And as we've been talking about here, I think, there's been a much greater and appropriately much better attention to the notion of children's rights. So, certainly at European level, there is a deliberate effort to try to bring this together, certainly in relation to the strategy on the rights of the child on behalf of European institutions. And this is to bring across, all of the relevant, policy initiatives that they are working in the same direction. Certainly, the Better Internet for Children strategy, which dates back to 2012, has been the flagship descriptor, for the European institutions' investment in this area. And that marked a shift from a Safer Internet program, which was obviously, very impactful for many years, towards better online experiences and supporting, a quality of online experience for young people. So that strategy is due alongside, many other initiatives at the moment to be reviewed and updated, and I think we can expect again a new strategy very soon, very much in tandem with the European Commission's own roadmap for the digital decade. And so, as there's so much, public investment in terms of digital transition and, a trustworthy environment for all, so that children's interests are best represented in that. And I think in that, we can expect, some important guidance towards the operation and the implementation of the important instruments. GDPR, we've been talking about significantly here. But let's not forget the Audiovisual Media Services Directive, which also has a very important protection of minors dimension. And that is being transposed, has been transposed into national legislation in many, many cases. And that gives audiovisual regulators a responsibility towards digital services, in this case, video sharing platforms, which come under the remit of communication or media regulatory authorities. So we're again seeing an alignment and a broader set of interests, which reflect not just on knowing your audience and knowing who is a child and having reassurance on that, but also in terms of the content on program on platforms, and requirements in terms of age appropriate safety by design, very very much part of the overall approach, and it'll have an impact I think on operational principles in many other ways, beyond the very specific focus that we're talking about here.
Yeah. One last rather detailed question, and then a follow-up general round at the end. The detailed question goes to you, Andrew, again. Brian rightly mentioned that we have been talking quite a lot about GDPR here, but not so much yet about regulation of audio-visual media services yet. Which brings me to the question to you, working for a data protection authority, whether you think that the cooperation between the different regulatory authorities, DPA here, audiovisual media services there, on a European level is organized in the best possible way, or whether you would see some possibilities of improvement here when it comes to the protection of the interest of children and minors.
That's an excellent question, Nikolaus. Well, to give our perspective as the data protection regulator in Ireland, specifically on audiovisual regulation and online safety regulation, we're very happy to see, as Brian mentioned, that the Online Safety and Media Regulation Bill has received approval from the Government of Ireland and has begun its passage through our Parliament, the Oireachtas. And this is linked because in addition to establishing a regulatory framework for online safety, the bill also transposes the Audiovisual Media Services Directive into Irish law. And it will also set up an online safety regulator with investigative and enforcement powers. I won't describe the bill in detail due to time constraints, but it's not dissimilar to the framework that's set up in the UK with the online safety bill and the powers that it will confer upon Ofcom. But it's significant from our perspective because one of the issues is that in the absence of such a regulatory framework up to now, the DPC has had to handle online safety issues or complaints relating to online safety issues, such as takedown requests for user-generated content on social media platforms, despite the fact that under data protection law, we don't have the tools to regulate these matters properly. And the issue is that often, the difference between data protection and online safety and other regulatory regimes operating on the internet is poorly understood. So, a piece of content might be very harmful and distressing. It might glorify eating disorders or something, but not involve any personal data or any identifiable individuals. And so data protection law in Europe creates very clear rules for supervisory authorities about what is and isn't in the scope. And we can only work within the rules and tools that we have. And so from that perspective, it's great to see this regulatory lacuna, this hole being closed in Ireland. And, we did make precisely these comments in our engagement on the bill, where we said that there needs to be robust cooperation mechanisms between the Data Protection Commission and this new regulator, for cooperation on complaints on areas where there is, overlap of our remits, etc. So it's a sentiment that we very much share, with the in terms of the question that you have asked. But having said that, we accept that this bill is in its early stages, and there is also work underway in Brussels on the Digital Services Act package, as we all know, which will, among other things, create a regulatory framework for legal online content. And so, it'll be interesting to see how these two regimes, interact. We are watching developments in this space carefully because, despite having our own remit and our own clearly defined tools, as another regulator online, we'll have to work very closely with the framework that emerges.
Yeah, which triggers probably the final question to all of you, which is a very general, let's look into the future question. And I would suggest to do it in reverse order. So starting with Rachael, then Iain, then Jürgen, then Andrew, and finally Brian. And the question is very simple and at the same time very complicated, I know. It would be, what should we do now? So how can policymakers, regulators, industry players work together in the most efficient way in the upcoming weeks, months, and years in order to achieve two goals? First of them, best possible protection for children. Second, best possible alignment of the regulatory framework as we see it in Europe and outside Europe in the future. So, Rachael, would you start?
Giving me a really hard job, Nikolaus.
Yeah, I know. I'm sorry for this, but it's a wish list, you know.
Definitely, yeah. Well, I mean, certainly what we're seeing in META is like just a plethora of legislation and guidance and frameworks. And I mean, they've all got like a shared goal of like providing greater protections for young people. So whether these initiatives are more privacy orientated or content or safety, we're starting to see them converge, which is a good thing, because I think in order to really protect young people online, I mean, you can't just look at it through one lens. It has to be multifaceted. But in saying this, there's challenges that come with that as well. So I think one of the things that we think would really help, and indeed this is starting already, and DPAs in Europe certainly seem to be aligned, is as far as possible for these legislative frameworks to really be underpinned by the best interest of the child, because that would be like the guiding star then for all of these frameworks. So we certainly think that would help. And that's whether it's privacy or content or safety. The other thing, and I mean, this tends to happen anyway, but it's just something we would greatly encourage, is that when new regulatory and legislative proposals are being scoped and proposed, that there's like a rigorous consultation period that would accompany that regulation or proposal as well. And that not only the views of companies and regulators and policymakers and trades, but really to get to the heart of this, to actually consult with parents, guardians, and in particular young people, because although that is definitely starting, we think that should really be at the heart of the matter and developing any new frameworks. And then just finally, and again, this is something that has started already as well, but just more discussion across industry and policy making on the more challenging aspects, such as age assurance. This has been initiated through EUCONSENT, that being one of them, but we would just encourage further collaboration, I think, across all parties, and in particular, again, with children and parents.
So give them a voice, right?
Yeah, give them a voice, yeah.
Iain.
Thank you. I mean, one thing I'll just say as an aside is we're working very closely with children and young people in terms of the EUCONSENT project, and we're lucky enough to be also working with Professor Sonia Livingston and Simone van der Hoff, a couple of academics very concerned about child rights and privacy, to try and keep the whole project honest. But to speak to your particular question, Nikolaus, I believe the real solution pragmatically is international standards. So we already have a British standard, BSI PAS 1296, for age verification, which is a little outdated. It's been around since 2018. So we're working on an IEEE standard and an ISO standard. The former is a sort of best practice process for age checking, and the latter a more general international framework. Because then what we can do is try to persuade regulators to point to those standards. The providers, whether that's something in-house or using a third party, can then build to those standards. We can define an a la carte menu of different levels of assurance, so levels of rigor or confidence for age checks, so that people can adopt a proportionate style. And of course, by having a common approach to age verification, you create the opportunity for interoperability, because we're talking apples with apples. When one provider's checked you to say a strict level of assurance, then another provider knows what that means, and regulators can say, right, for this particular harm, we think it's appropriate to check people to that strict level. which may, for example, involve a liveness check, which is one of the other questions in the chat, making sure you're not just holding up a photo of your older brother, but you are actually a real person doing the check at that point in time. So you wouldn't want to do that for every age check, but for buying a knife online, that might be proportionate. And then if you've got those international standards, on top of that, you can add audit and certification. Certainly to join our EU consent network, you need to be certified to be operating to that standard. And that way, through co-regulation, regulators get some comfort that operators are behaving well, that they're not, trying to be, harvest data or abusing their privileged position, because we do need to be a regulated industry, because we will be dealing with a lot of personal information of one sort or another, if only for a brief period of time. But I think the future and alignment is delivered through international standards.
Thank you. Thank you, Jan. Jürgen.
Well, I can only second that. I feel a little bit like everything has already been said, but indeed, international standards are key. Fragmentation of rules is really the enemy for digital industry. If you are a digital industry, you are cross-border by nature, and so the rules, I think, need to be adapted as much as possible to that as well. So my recommendations for legislators would be to try to approach rulemaking from a cross-border perspective as much as possible, if possible multi-regional, and if possible maybe also global. One example in the GDPR is an example on how you should not do it, right? Which is the agreement about the different ages of consent in the European countries. That has been and is still unimplementable as such. Most of the companies would strive for the highest age threshold, because it's simply impossible to adapt services to one country for 14 and to another country for 13 and then 15 and then 16. So what I really want to call for is to avoid situations like that in the GDPR. And then maybe the second one is, and that has already been said by Rachael as well, is try to include as much as possible parents and parental organizations into the effort as well. If it's not by regulation, it's maybe by supporting industry in their awareness efforts, which can be very costly. And any type of support by governments is always more than welcome. Thank you.
Mm-hmm. Thank you very much. Andrew.
Thanks, Nikolaus. Just a couple of quick points from me, if I may. I think it's important to point out, first of all, that the DPC isn't a policymaker. I feel I should point that out because, I don't see any other policymakers on the panel, so I wouldn't want to be accused of being one.
Fair enough. Yeah.
as a regulator, we apply the law as set by policymakers, of course, but that doesn't mean that there isn't a time and a place for regulators to give their views. I've already talked about our engagement on the Online Safety and Media Regulation Bill. We also made a submission last year to the National Curriculum Council Association in Ireland on the draft primary curriculum framework, calling for a digital citizenship component to the draft primary framework curriculum that specifically considers data protection. So all of this to illustrate that regulators can and do and share their insights with policymakers when on policy proposals that affect our remit or that have a significant data protection component. But returning to the question, so rules are set by policymakers, regulators enforce them, whether by consultation and guidance or by enforcement, and ultimately organizations follow them. And it's very important that we all pay close attention to the way that policymakers are thinking as well, because if we take the example of the Digital Services Act package, the recent reports say that there's strong appetite, at least in the European Parliament, for significant new restrictions on ad tech. And of course, these discussions are still at an early stage, and the Digital Services Act is years away. But part of ensuring alignment is making sure that we are keeping abreast of the thinking of policymakers and seeing where the conversation is headed. And also, just finally, I would add a couple of extra groups that I think are missing from the question, who also have a role to play in ensuring alignment, which is civil society organizations such as NGOs and researchers and academics. I know that, for example, one of the organisations in Ireland that Brian O'Neill is associated with, CyberSafe Kids, does an excellent annual report which has a survey of the online habits of children aged 8 to 12, which consistently shows, the amount of them that are using platforms designed for children aged over 13. Now that's a systemic issue; it's not unique to any platform, but it shows, the important role that they play in showing that we, have a lot of work ahead of us. And then, of course, children themselves, who have their right to be heard under Article 12 of the UNCRC, they should always be included in the conversation. And these are all very important pieces of the puzzle. So everyone has a role to play in terms of ensuring alignment.
Yeah, absolutely. Thank you, Andrew. And Brian, finally, last but not least.
Well, very good. And in this case, with such a wonderful panel, my fellow panel members have really hit all the right points, and I can only endorse what they're saying. I really do take the point, just to underline it again, as Rachael said, where we are now, and in terms of informing this discussion, the best interests of the child principle is a vital step forward, and having that reflected in all of this high-level policy discussion. And as Jürgen mentioned, we are discussing GDPR, in the context of children, but that wasn't always the case. And I think there are clear examples of what we would not want to happen. One thing I would just add, finally, is in terms of the vital importance of close collaboration and harmonization. We are in a situation where there is a lot happening. There's a lot of activity, and I think various different stakeholder groups are empowered to contribute to this broader debate around new regulatory approaches and regimes and whatnot. The worst outcome would be a real clash between all of those and that lack of alignment. We're seeing some very high level interventions, and I think let's not lose sight of the value of the multi-stakeholder approach, which we've always spoken to, and the value of all of these inputs, including the voices of children and young people, can only benefit the outcome.
Yeah. Thank you so much, Brian, also for making the point that this is just the start of the conversation that we need and not the end. However, I think we are coming to an end here for today. I need to thank all of you most warmly. It was very, very, very interesting to me. And if this is the indicator whether something is useful or not, then it was most useful what we have been doing here. I really appreciate all your inputs. And I thank all of you. And I think that Stuart is scheduled to come back and to say goodbye to everyone. Stuart? Yes, here he is. Yeah. Please, go ahead.
Thank you very much. Well, Professor Nikolaus Forgó, you really chaired a very well-balanced session. Everyone was self-disciplined, but you kept the time and made sure everyone's voices were heard. And I think the message from this is that everyone, from whichever perspective they have, that everyone has a role to play and to cooperate and to help achieve the best interest of the child. So thank you for all panel members as well. Jürgen, Andrew, Iain, Professor Brian O'Neill, and Rachael, of course. And thanks, of course, the audience for joining us for this session. The video of this session will be available soon after the session has ended. And I'd like to see those thumbs up. That's very nice in the corner, showing you like the session. We welcome everyone's feedback and ideas for future online and live events, because in fact, we're now organizing our next live event, which will be a hybrid, both live and online event. It will be hosted by law firm Latham & Watkins, take place in London on Wednesday, 18th of May, when the subject will be Making Your Case in Europe, Defending Against Data Protection Authority Inquiries and Sanctions, with speakers from France, Germany, Ireland, and Spain, and indeed the UK. And the following Wednesday, 25th of May, we have another completely different session with a focus on the UK government's reform of the Data Protection Act. And this will take place as an in-person event only, hosted by Norton Rose in London. The dates for our Winds of Change, the Privacy Laws of Business 35th Anniversary International Conference, are 4th to 6th of July, St John's College, Cambridge, and that will be in person, and we're offering a hybrid option as well. And we look forward to meeting you there in person. You'll also, registration is now open, and we've announced our first group of speakers, which you'll find on our website. And we look forward to keeping in contact with all of you. via our news, our UCAN international reports, events, and podcasts. So full information of all our PLMB events and other services is at privacylaws.com. So thanks again to our panel today, our speakers, and you, our audience. So that's all for now, and goodbye.
Goodbye.